March 11th, 1994. I filed a motion to rehear in JDR court as I had been instructed by the Commonwealth's attorney, and complied with the order for psychological evaluations. I tried to comply. March 1994, I was excluded from the psychological evaluation process. The psychologist, Thomas Coe, canceled my appointment and refused to evaluate me as directed by the court. Dr. Coe's prejudice is blatantly obvious. The APA guidelines call for the same evaluator for all family members. Yet I was excluded from the evaluation process and had to go to my own counselor for evaluation. This was, in effect, an ex parte hearing. You're supposed to have all parties at any hearing, but in the context of a psychological evaluation process, it became an ex parte hearing, in effect. I was denied the right to face my accuser, the psychologist. May 13th, 1994. Unconstitutional order restricting my speech. Despite the fact that Kathy had caused any conflict, which she alleged, regarding diet, when she changed her diet back to a meat-based diet, Judge Hoover ordered supervised visitation prescribing my speech with the children as to diet, leather clothing, and the court case, based on the prejudiced evaluations by the quote-unquote psychologist who refused to interview me. On my motion to rehear, Hoover refused to hear divorce matters never addressed, refused to let my oldest daughter testify, she was 8 years old at the time, as per the Commonwealth attorney's promise to me. So again, due process was denied. My evidence was ignored. If they don't like your evidence, they just ignore it. Evidence of Kathy's fraud. During a visit sometime after Kathy made diet an issue by reverting to a meat diet, my kids informed me that their mother told them she had consumed meat behind my back even before we moved from California to Virginia. Further proof that she had lied and fraudulently induced me into moving to Virginia. She had pretended to be a vegetarian to get me to agree to move to Virginia. May 16th, 1994. The court refused to provide a copy of the psychological evaluation. I appealed the supervised visitation and speech restriction order and refiled the motion to rehear in the circuit court. The JDR court refused to give me a copy of the 9-page psychological evaluation, even though I was representing myself. I was acting as my own attorney. In July 1994, I finally obtained a copy of the evaluations from the circuit court file for review and response. 8/1/94 rather. Fraud and breach of contract complaint. I filed a fraud and breach of contract complaint in the Williamsburg Circuit Court after Judge Persone, who inquired at the docket hearing as to whether fraud was involved, requested a more formal complaint than the motion to rehear divorce matters. My 38-page complaint explained how my discrediting Kathy had revealed her fraud beginning in 1989 and demonstrated her 5.5-year attempt to conceal it with at least 60 instances of lying in order to maintain the facade of lies she told, which allowed her to obtain custody in 1989. I proved her lying by I had been forced to tape record her conversations. I got her on tape admitting that she committed fraud, that she lied and committed fraud to get out of the marriage. August 3, 1994, I subpoenaed my oldest daughter and was informed she would be in court. I also subpoenaed the psychologist's records of evaluations of the children, having shown in my response to evaluations how all of the serious accusations against me were refutable, unsubstantiated generalizations based on the psychologist's speculation. Again, he didn't even talk to me. He just assumed